I lived in the margins of documents other people never read: safety checklists, inspection logs, time-stamped photographs of load-bearing brackets and fall protection anchors. While everyone else was chasing bonuses and corner offices, I was the guy squinting at anchor bolt torque specs at 6 in the morning, alone, with a flashlight and a clipboard. That was my identity. Not loud, not political, just thorough. I had been a senior safety inspector at Meridian Construction Group for 12 years. 12 years of showing up early, staying late, filing reports that half the executive team probably never opened. 12 years of watching projects get built the right way, my way, and going home knowing nobody got hurt on my watch. That was enough for me. That was everything. My direct supervisor during those years was a man named Gerald. Patient, old school, deeply principled. He used to say that the job of a safety inspector was to be the most boring person in the room. If you were exciting, something had gone wrong. Gerald retired in the spring of my 11th year, and I genuinely mourned the loss of working for him, not because I was sentimental, but because I understood, even then, that not every manager was built the way Gerald was built. I was right to worry. Her name was Sandra Hollis. She came in as our new VP of operations about 4 months after Gerald left. She had a background in logistics and project acceleration, which is a polished way of saying her entire career had been built around one principle: finish faster. She walked into her first all-hands meeting wearing a blazer that probably cost more than my monthly car payment, and she opened with a phrase that I would come to hear dozens of times over the following year. "Speed is the product," she said. "If we're not moving, we're losing." Fine. I understood the business pressure. Meridian had won a $47 million contract to build a regional distribution center outside of Columbus, Ohio. The deadline was aggressive, the penalty clauses for delay were steep, and the client, a logistics company called Hartwell Group, had made it very clear they were watching the calendar. I understood all of that. What I didn't understand, what I would never understand, was how any of that pressure justified what she started doing in month 2. The first time I flagged a problem, it was a scaffolding issue on the east wing. The anchor spacing was off by a measurable margin, and 2 of the uprights showed stress fracturing, consistent with overloading. I submitted the inspection report through our standard system, flagged it urgent, and sent a direct email to my supervisor, who was now Sandra. Since my previous department head had been reorganized out with photographs and the specific OSHA standard we were in danger of violating, she called me into her office the next morning. She didn't offer a seat. "Marcus," she said, not looking up from her laptop. "I've read your report." "Good," I said. "We need to pause work on the east scaffolding until—" "We're not pausing." She closed the laptop. "We are 3 days behind schedule as of this morning. 3 days that are going to cost this company real money. What I need from you is a solution that keeps us moving." I told her there was no version of a solution that kept us moving on that scaffolding without first correcting the anchor spacing. I showed her the photographs on my phone. I read her the OSHA standard verbatim from memory because I had been living inside these regulations for 12 years, and I knew them the way other people know their home addresses. She looked at me the way people look at someone who's just said something deeply inconvenient. "I appreciate your thoroughness," she said, "but I need you to understand that this organization has always found ways to balance compliance with momentum. That's just how we do things here." That phrase, "that's just how we do things here." I heard it so many times over the next several months that I started hearing it in my sleep. It was her all-purpose response to anything that slowed the project down. A missed equipment certification? That's just how we do things here. A subcontractor whose fall protection harnesses were 3 years past replacement date? That's just how we do things here. A temporary electrical panel installed without a proper lockout-tagout procedure? That's just how we do things here. I filed every single violation, every one, through the official internal system, with photographs, with timestamps, with the specific code section cited. I sent copies to my own personal email, which then backed up automatically to cloud storage I had maintained for years, not because I anticipated any of this, but because I had always believed that if something went wrong on a job site and someone got hurt, I needed to be able to prove exactly what I had reported, exactly when I had reported it, and exactly what was done in response. Gerald had taught me that. "Document like you're already in court," he used to say, "because someday you might be." What I noticed, over time, was a pattern in the responses to my reports. Acknowledged, reviewed, filed for assessment. Sometimes a partial correction would be made just enough to avoid a direct violation, not enough to actually fix the underlying problem. And the project kept moving, faster and faster, as the deadline approached. In month 8 of Sandra's tenure, something happened that changed everything. A worker named Danny, a framing crew lead who had been with Meridian almost as long as I had fell from an improperly secured ladder on the 4th floor of the west section. He didn't die, but he broke his wrist badly enough to require surgery, and the fall itself was 6 feet onto a concrete subfloor. 6 feet in the wrong direction, and we're having a very different conversation. I had flagged that ladder mounting configuration 11 days earlier. I had the report. I had the photographs. I had the timestamp. OSHA was notified, as required by law. An investigation began. And that's when Sandra called me into her office again. This time she closed the door. "I need to know," she said, leaning forward across the desk, "exactly what you're going to say when OSHA talks to you." I told her I was going to tell them the truth. All of it. She studied me for a long moment. "Marcus, I think you need to think carefully about your position here. You're coming up on a significant milestone with the company." I knew exactly what milestone she was talking about. My pension vesting date was 14 weeks away. 14 weeks, and 12 years of contributions became permanently mine regardless of my employment status. Before that date, if I left or was let go, I would walk away with a partial benefit that amounted to maybe 30 cents on the dollar. I looked back at her across the desk and said nothing. "I just want to make sure we're aligned," she said. "That's just how we do things here." I left her office and went straight to my car. I sat in the parking lot for a while. Then I called my wife and told her we might need to have a serious conversation that evening. She asked me if I was okay. I told her I was fine. I wasn't entirely sure that was true. What happened over the following 3 weeks was methodical on both sides. OSHA conducted its initial site inspection. I answered every question truthfully. Sandra submitted the company's official incident response, which attributed Danny's fall to personal protective equipment misuse, meaning they tried to put it on Danny. I submitted a written statement to the OSHA investigator that directly contradicted that characterization, attached to which were my 11-day-old photographs and inspection report. 2 weeks after the OSHA interview, I was called into a meeting with Sandra and a man from HR whose name I had never learned before that day. The HR representative opened a folder and read from a prepared document: performance concerns, failure to collaborate, documentation practices that were described as outside established company procedures, a pattern of creating unnecessary project delays through excessive reporting. I sat there listening and thinking about Gerald. Document like you're already in court. When he finished reading, Sandra looked at me and said, "We're going to need to let you go, Marcus. Effective immediately." I asked for a copy of everything they had just read to me. The HR representative looked at Sandra. Sandra nodded. He slid the folder across the table. I picked it up. I stood. I said thank you, and I left. I want to be clear about something. I did not flip a table. I did not raise my voice. I did not say anything dramatic or threatening. I walked to my office, packed the small number of personal items I kept there, a photograph of my wife and me at the Grand Canyon, a coffee mug that Gerald had given me when he retired, a worn paperback copy of a book on risk management that I had annotated over a decade, and I carried them to my car in a single cardboard box. Then I drove to a coffee shop 3 blocks away, ordered a large black coffee, opened my laptop, and began building a timeline. I had 847 safety reports filed over 12 years. I had 2,300 photographs indexed by date and job site. I had email threads going back to my very first week at Meridian. I had every single response or non-response to every single report I had ever submitted. And I had 12 days of OSHA investigation still ongoing, during which the investigator would, at some point, be very interested in what I had to share. I didn't call a lawyer that day. I called Danny first. He picked up on the second ring. His wrist was still in a cast. He had 3 more weeks of physical therapy ahead of him. I told him what had happened. He was quiet for a moment. Then he said, "They're going to try to blame me for this, aren't they?" I told him they already had. He said, "What do we do?" I told him to keep every medical record, every appointment, every correspondence from Meridian and their insurance carrier. I told him to write down everything he remembered about the conditions on that floor in the week before his fall. I told him not to sign anything from anyone without reading it carefully 3 times first. Then I did call a lawyer, an employment attorney named Rhonda, who had been recommended to me by a friend who had gone through a wrongful termination case 2 years earlier. I sent her a summary of the situation that evening, 6 pages, single-spaced, with a table of contents and an appendix of key documents. She called me back the next morning and said, Marcus, this is one of the most organized pre-litigation packages I have ever received from a non-attorney. I told her I had been preparing for a version of this for 12 years, without knowing it. She explained my options. Wrongful termination. Whistleblower retaliation because my firing had occurred during an active OSHA investigation in which I was a key witness. Potential individual liability for Sandra, depending on what the investigation turned up. She told me the pension timing was significant, terminating an employee within a vesting window, particularly in connection with protected activity, had a name in employment law, and it was not a flattering name for employers. I asked her what she thought the realistic outcome was. She paused and said, "Tell me more about this cloud backup." I told her about the 12 years of inspection logs, the photographs, the timestamps, the email chains in which I had explicitly flagged violations that were subsequently overridden or ignored. Another pause. "I want to be careful about giving you false expectations," she said, "but I will tell you that the documentation you're describing significantly changes the landscape of this case. The question of whether they can prove their performance justification falls apart the moment a jury sees 12 years of thorough, consistent, praised safety work followed by termination 11 days after you gave testimony that contradicted your employer's official incident report. The OSHA investigation concluded about 6 weeks after my termination. The findings were not good for Meridian. Multiple citations. One classified as willful, meaning OSHA had determined the violation was not accidental, but reflected a conscious disregard for safety standards. The proposed penalty was significant. More importantly, the investigation findings were now part of the public record. I found out about the OSHA findings on a Tuesday afternoon. On Thursday of that same week, Rhonda called me with news I had not anticipated. The entity that insured Meridian for the Hartwell Distribution Center project, a commercial insurer called Cascade Risk Management, had apparently been watching the OSHA investigation closely. Because the project was still incomplete, because the penalty findings had triggered a policy review clause, and because their own risk assessors had now visited the site and come back with a report that Rhonda described as alarming. Cascade's legal team had made contact with Rhonda's office. They were not on Meridian's side. They were, in fact, conducting their own internal investigation into whether Meridian's conduct during the project constituted a material misrepresentation of risk, which, under the terms of the policy, gave Cascade grounds to deny coverage on certain claims and potentially void specific policy provisions related to the project. In other words, Meridian was facing an OSHA penalty, a wrongful termination lawsuit, and the possibility that their insurer was preparing to walk away from coverage on a $47 million project right in the middle of construction. The Hartwell Group noticed. How could they not? Their project was now under federal safety scrutiny, the contractor's insurance situation was uncertain, and construction had slowed because several subcontractors had pulled their crews pending clarification of the insurance picture. Hartwell's project manager sent a formal notice of concern to Meridian's board of directors. That's when I started hearing things through back channels. A site foreman I had worked with for 7 years texted me one evening. He wrote, "They're saying your name in board meetings, Marcus. Not in a good way at first. Now I'm not sure." 3 days later, Rhonda received a call from outside counsel, retained by Meridian's board, not the in-house legal team, not the same lawyers who had been advising Sandra, but a separate firm brought in specifically to assess the company's exposure. They wanted to know if I would be willing to discuss a resolution. I told Rhonda to ask them what resolution meant. What it meant, it turned out, was this. The board had conducted an internal review of my termination after pressure from both the OSHA investigation and the Cascade situation. The review had determined that my performance record did not support the documented justification for my firing. The review had further determined, and I want to be precise about this because the language matters, that my termination had occurred within what the reviewing attorneys classified as a protected disclosure window, meaning I had been fired while serving as a witness in a federal safety investigation. Sandra had been placed on administrative leave while the review was ongoing. The outside counsel told Rhonda that the board was committed to making this right. They offered full reinstatement, back pay for the termination period, and an accelerated vesting of my pension as if I had completed the full period without interruption. Rhonda told them she would take the offer to her client. She called me immediately afterward. She laid out the terms clearly and professionally. Then she said, "Marcus, I want to make sure you understand you have other options. We could litigate. Given what we have, we could potentially do significantly better than what they're offering." I asked her what litigation would look like. She was honest, 18 months minimum, possibly 2 years. Depositions, discovery, stress, uncertainty. Even with strong documentation, trials had variables. I thought about Danny. I thought about my wife. I thought about Gerald and what he would have said. Then I asked Rhonda one thing. Could we add a requirement that the company implement a third-party safety audit of the Hartwell site before work resumed, with the results submitted directly to OSHA? Rhonda was quiet for a second. Then she said, "That's an unusual ask." I told her it was the one I cared about most. She called back the next day. They had agreed. The settlement was signed 6 weeks later. I won't share the exact figures because the terms included a confidentiality provision that I intend to honor. What I will say is that the pension I had spent 12 years building was intact. The back pay covered the period I had been without income. And the Hartwell site was audited by an independent firm before a single nail was driven after the settlement date. Danny received a separate settlement from Meridian's workers' compensation carrier. His wrist healed. He went back to work for a different company about 4 months later. He texted me the day he got his new job offer and said, "Thank Gerald for me." I told him I would. Sandra Hollis resigned from Meridian during the period of her administrative leave. I don't know where she went. That's not something I spent any energy tracking. The in-house legal team that had advised the company during the period of my termination also departed quietly, several months later. These things have a way of unraveling. What I find myself thinking about now, and I think about it more than I expected to, is not the settlement, not the vindication, not even the moment Rhonda told me the board had reversed course. What I think about is the moment I sat in that coffee shop 3 blocks from my former office with a large black coffee and a laptop and started building a timeline, because that moment was only possible because of 12 years of habit. Not drama, not confrontation, not grand gestures of resistance, just the daily discipline of writing things down, photographing what I saw, saving what I sent, trusting that accuracy, maintained consistently over time, was its own form of protection. I had never planned to use any of it. I had documented because it was right, because it served the job, because Gerald had told me to, and Gerald was always right. But here is what I know now, more clearly than I knew it before. The paper trail doesn't just protect you after something goes wrong. It changes what can go wrong in the first place. My 847 reports were not just evidence in a lawsuit. They were 12 years of proof that I had done my job with integrity, and no termination letter, no matter how carefully worded, could erase that record. It existed independently of what my employer thought of me, independently of what Sandra wrote in a performance review that bore no resemblance to my actual performance. The record was the truth, and the truth was patient. It could wait. My wife asked me, one evening, a few months after the settlement, whether I was angry, whether I wished I had done something differently, gone public sooner, escalated faster, made more noise. I thought about it seriously before I answered. I told her no, not because I wasn't affected, I was. There were nights during those weeks between termination and resolution that I did not sleep well. There were moments when I doubted whether doing everything by the book would be enough, when I wondered if 12 years of doing the right thing was going to matter against an organization with resources and lawyers and incentive to protect itself. But noise wasn't the answer. Noise would have given them something to argue about. Instead, I gave them something they couldn't argue with. 847 reports, 2,300 photographs, every email I ever sent, every response I ever received, every date, every time. A few weeks after the settlement, I started getting calls from former colleagues, people who had watched what happened, who had their own documentation, their own concerns, their own stories of being asked to look the other way in the name of momentum. I'm not a lawyer. I can't tell anyone what to do. But I told every one of them the same thing Gerald told me on my first week at Meridian. Standing in the rain on a job site outside of Cleveland, watching me write notes by hand in a notebook I kept in my jacket pocket. He tapped the notebook and said, "Keep doing that. Always." I didn't fully understand why he said it with such certainty. I thought it was just professional advice sound, but ordinary. It wasn't ordinary, it was armor, and I wore it every day for 12 years without ever realizing how much I would need it. If you've ever been in a situation where you knew something was wrong and you said so and you were told that speaking up was the problem, this is for you. I'm not going to tell you it's easy. I'm not going to promise you it works out every time. What I will tell you is that the version of me who kept his head down and stayed quiet would not have had a case. He would have had a grudge and a gap in his resume and a pension check that didn't reflect a day of the 12 years he had given. The version of me who documented everything had something more durable than that. He had the truth, dated and time-stamped, backed up in 3 separate locations, ready to stand up in front of anyone who needed to hear it. Speed is the product. That's what she said on day 1. She was wrong. Accuracy is the product. Integrity is the product. The record that outlasts every bad decision made in the name of a deadline, that's the product. And I never stopped making it. Ever kept documentation that saved you or wish you had? Drop it in the comments. And if you believe in doing the right thing, even when it costs you, hit subscribe. We tell these stories because they matter. And because you deserve to know you're not alone.